We're going to talk about the UGC rules. Now, the Supreme Court has pressed pause on these UGC equity regulations, but it seems like the political and the social fault lines are only getting sharper. Let's break that down for all our viewers. Take a look at this, ladies and gentlemen. The Supreme Court has stayed the University Grants Commission's new equity regulations, raising fundamental questions about how we define and fight discrimination in our educational institutions. The court didn't reject the intent behind these rules. Instead, it questioned whether they were written clearly enough or not, whether they might be misused, and whether they accidentally left some students without protection whilst trying to protect the others. Let's break that down for what the court said, what the petitioners are worried about, and what are the supporters of these rules claiming. Well, the bench, led by Chief Justice Surya Kant himself and Justice Joy Malia Bagchi, heard the petitions challenging these rules. Now, the court observed that the provisions are vague and they're open to misuse. They asked why certain categories were isolated whilst others, like ragging, were seemingly overlooked. The court essentially said that writing rules about discrimination requires more than legal drafting. It requires deep understanding of society itself, and in this context, directed to form a panel with 2 to 3 eminent jurists to look into these rules. And the core of the legal battle lies in how we view protection in the first place. Petitioners argue that by specifically defining caste-based discrimination for only certain groups, the rules exclude general category students. They also said there is already a general definition of discrimination in Regulation Part 1, Subclause E. So, the separate caste-based one is not needed and could create problems in the future. This potentially violates the right to equality under Article 14 as well. But on the other hand, those defending the regulations said that they aim to promote real inclusivity and follow the Constitution's vision of equality. They argued that the word only in the definition should not be read so narrowly, and discrimination can be understood in a wider sense. They added that anyone facing issues can still file complaints under these rules, and that there is no need for a stay without hearing the full defense in its entirety. Now, they compared it to how disability benefits are not given to everyone, but are focused where it is needed. They also warned that staying these rules, putting them in abeyance, suddenly could create law and order problems on campuses. Is it possible to write anti-discrimination rules that protect everyone without diluting protections for those who need them the most? How do we balance constitutional commitments to affirmative action with constitutional commitments to equality? Will the centre roll back? And that's a major question. Will it roll back or fully rewrite the UGC regulations after this stay or abeyance? Or will it push to defend and modify them in these coming weeks? We're going to quickly go across and go through these questions. With me on the broadcast, Ashok Bharti, Chairman, National Confederation of Dalit and Adivasi Organizations. Rahul Ishwar, author and activist, is soon going to be with us. And Sanjay Chadha, advocate with the Supreme Court, with us here on the broadcast. Mr. Bharti, let me quickly begin this snowball with you. We've been discussing this for the last 2 days as well. Some argue that any stay on these kind of measures aimed at social justice is regressive, something that the court themselves said, some of those top courts that are going to be playing out on our screens as well. On the other hand, others say that this is just badly drafted, and a badly drafted justice can cause more harm than no justice at all. Where should the balance lie? After today's arguments, I'm sure you've heard them as well. How do you view the Supreme Court stay? Is it a setback? Is it a pause? Are we looking at an improvement of the laws? Are we going to look at a completely different picture in the days to come? What's going to happen next?
No, I think what Supreme Court has said and stated, we had expected that very well, because we know that the way things move in this country, socially, politically, educationally, the very first chance where the equity and inclusion is brought in picture, whether it is the case of the reservation, whether it is the case of quota or SC/ST law or anything, the Supreme Court has uh, only one message: put on hold everything. So they have done it. We have no issue on that, and let the Supreme Court take its time and decide on these.
But Mr.
But I
Bharti,
would
aren't
certainly
those
ask.
progressive steps? Matlab, just to say that they don't have any other option would be diluting the purview of what the Supreme Court said. I was going through the the arguments as well. There are several other cases. The entire the top court of the land can't just keep everything aside and give the entire day to these regulations and this particular case.
Absolutely.
I mean, just to say that they have no other option, they put a stay because this is the pattern and this is predictable. I think that's where we're going a little wrong. We're diluting this. But talk to us about the new committee. There's a new committee that's going to be set up. Notices to the center have been issued. I mean, the train has certainly moved to another station.
No, you know that one is that the modality that Supreme Court has normally adopt in cases where the scheduled caste, scheduled tribe, OBC seeks justice. That is one modality. The second is the issue of the justice. And I have read that there are two. The one important comment that on Article 3C and 3E,
Yeah,
which
yeah.
Supreme Court has commented upon, and I'm sure that the Supreme Court judges know the caste-based discrimination is certainly different from the racial discrimination or gender discrimination or other kind of discrimination. And particularly in case of the scheduled caste, scheduled tribes, and OBCs, the caste discrimination is much more serious. Let me put a very serious, a small, example that recently in Rewa in Madhya Pradesh, one Brahmin, removed the choti of a Yadav person. He was not a scheduled caste. So I guess that in this country, in this culture, or in this religion, whatever you can say, the upper caste think that they can do everything and get away with this. Whether it is discrimination, whether it is exclusion, whether social boycotting. You know that when this so-called agitation begin, they have given a call: no doctor will visit Dalit, Adivasi, OBC, and no
Yeah.
shopkeeper
And
will
some other
sell them any
horrible things have
material.
also been said. You're absolutely right. Some other horrible things have also been said.
Yeah.
But,
So
I
that's what
think it
I'm
was
saying, that
Advocate Indira
in this
Jaisingh who had said,
country,
it was the advocate who had said,
I'll
yeah,
just complete
it
the
was about
sentence.
discrimination within discrimination. The 3E and the 3C and 3F point that you're talking about. The
That's what
three,
I'm saying.
yeah,
3E does not specifically talk about the caste-based discrimination with the scheduled caste, scheduled tribe, and OBC. It talks discrimination in general. There are two kind of discrimination in this country. One, discrimination in general, and this is the accepted norms and the rule of law in this country. The discrimination with scheduled caste, scheduled tribe is given a different connotation
okay.
in the law in this country, and that's what the UGC has done. I am not, so I'm sure that when the case will go on argument and when they will learn it, they will argue with each other.
Right.
I'm sure those issues will be taken care of. But at this point of time, I suppose the question that Supreme Court had it in mind, the way there is a
But Mr.
hooliganism going
Bharti,
on,
I'm just
so
trying
they
to be the
want to
devil's
twist that.
advocate here. Imagine there's a disabled person, especially abled rather. They will say that why not give us a subclause as well? If Part E says discrimination all across for all stakeholders, then the people who are facing discrimination on the basis of gender will come out and say, why not give us another subclause that talks about gender discrimination? Why only give a specific subclause for caste discrimination? I'm just asking you a question here. Think about it. I'll come to you right on the other side. Let me bring in the advocate with us on the broadcast as well, Sanjay Chadda, advocate with the Supreme Court. So, in terms of maintainability, in terms of validity, decoding the constitutionality of it all, the Supreme Court has not struck down these regulations. It has put them in abeyance, citing vagueness, citing overbreadth. How should viewers really understand this move? And we're not here to, miff anybody or a particular community, not even Ashok ji. He'll also, calmly listen to what you have to say. Over to you, Mr. Chadda. What do you say?
Kabir, thank you very much. But I was surprised as to how Adani Ashokji has said that he was expecting the judgment to be on the same line. I was surprised. Look, we have to see whether Ashok ji, me, or anybody, we are now looking for a caste neutral country. We are not here, inclusive society is what is required today. It is not that and if we will keep on fighting on these things, and I have also heard Shri Ashok ji saying that in Riva something had happened. Our country is not a small space.
But
It's such a
you see,
huge
Advocate
country.
Chadda, the supporters of these regulations, just like Ashok ji as well, I've been speaking to a couple of them over the last 2 days. They're saying that yes, we need to become a more inclusive socio-cultural society, and for that,
Exactly.
these regulations are necessary.
No, Kabir, I have not yet completed. Even I am the supporter of this law.
Okay.
But, please allow me 1 minute.
Yeah. Go
But
ahead.
as I said, that caste inclusive, we caste neutral. We need a, so where here what had happened, you have to what the Supreme Court today said, that if we see the test of fairness, test of reasonableness is failed. What is test of reasonableness? That you know it is very clear that in this law we are uh, you know rendering a set of persons without remedy. This is very clear. Ashokji will agree to it. We are leaving a set of people who are so-called general category. Their remedy is not there. And it is prima facie from the very first day when there is a complaint. They are, the complaint is filed against, let's say what I mean, journal category student, and from day one, within 15 days, it has to be concluded. There are various incidences. We are not going into that now. I just tell you, this particular law which is being challenged, it is challenged on 4 counts.
Okay.
First, that it is one sided. It is talking about one side, so that I just explained. Second, which is also that it is article 14, 15, and 21. It is violative of these 3 articles. How? If you want, I can elaborate that also. The definition which is given, 3C, violation, 3C definition is not very clear. And fourth, which is very important, is if, let's say, what will happen if there is a false complaint. So these were the 4 things
Yeah.
where
Yeah.
uh, it was challenged on these 4 counts. Now, what Supreme Court says, they have given a very welcome suggestion, I feel, that let not the court, not the government, not anybody else,
Okay.
let certain jurists, important, prominent jurists,
Yeah.
should
Yeah.
evaluate it. Where is the need, and what
You're
kind of
absolutely right.
thing
We
there.
do need to specify on what this committee is going to look like. That's coming right on the other side. Do stay on with us, Advocate Chadda and Bharti ji. Do stay on with us. A quick commercial breather. And on the other side, we'll talk about the vagueness and the misuse aspect that the Supreme Court highlighted once again today. So with the UGC rules now in abeyance, the spotlight shifts to a question whether these laws were badly drafted or was the law flawed in the first place? With me on the broadcast, Ashok Bharti, who's the chairman, National Confederation of Dalit and Adivasi Organizations. Rahul Iswar, author and activist. I can finally see you on my screens. Many thanks for joining us here. Sanjay Chadda, advocate, Supreme Court. Rahul, let's give you a quick voice. I need to go across the board, so please exercise brevity, my request to all. You've argued, yesterday we were talking about the same thing. You argued that UGC, these regulations, they risk overreach and there could be moral policing, and that's what you were talking about. Did today's Supreme Court stay that the rules in abeyance, do they validate those concerns? How do you look at what the top court said today and the top courts that were made from the top court?
Absolutely. Those concerns are validated by the Honorable Supreme Court and the Apex Court. Let's remember, caste, community can be very contentious issues. So as you rightly pointed out earlier, the laws could have been drafted better. There were a lot of spaces for ambiguity. There were spaces whether the laws could be misused. Such a sensitive issue like caste, religion, race, they ought to have been dealt with more sensitively. That's the reason why the Savarna base of BJP also revolted against it. So it could have been, such a sensitive issue. This can, bring forth those fault lines in Indian consciousness and psyche. So it should have been handled with much more care. Thanks to Honorable Supreme Court that they stepped in. But I still stand with the point that our Adivasi, SC, ST, OBC community brothers need to be helped and more justice should be given. But please remember, it should not be.
So what's the right way? What's the right way then, Rahul? How do we go about that? You're talking about social and socio-political fault lines. A portion of society is putting sweets in each other's mouth. The other portion is, really not very happy with what happened in the Supreme Court. Where are we headed then?
I mean, I would humbly request those kind of ladoos being shared. These can be avoided, because that can really rub salt in another person's mind. So let us be responsible about these. Let us have social insight. Let us respect each other. Find consensus. Please remember, the way ahead in any contentious issue, whether it is a black and white issue in America, whether it is a caste issues in India, it is by consensus. Let the social leaders, spiritual leaders, socio-political leaders come together and talk and find solution. Just one submission. We need to have a mechanism to check the fake complaints. Otherwise, the kids will always be at risk, and they will always feel that they will be persecuted by a false complaint. So there needs to be checks and balances. But we have to bring two aspects together. It is not A versus B, but it is always A plus B. That is integration.
I think that's a great way to put it. A plus B, not A versus B. So, Ashokji, the court has flagged misuse and vagueness. We were earlier talking about discrimination within discrimination. Many, lawyers argued, when you have Part E, then is there really a need for Part C? And if there is a need for Part C, then why not specific parts for, gender inclusion, part for disabled people, a special section and a clause for women? I mean, those are some questions that will come about. Is the answer now to refine these safeguards and move front? How do you see this new committee being worked around? क्या लग रहा है आपको? कहाँ जा रही है ये रेलगाड़ी?
Okay, the one thing that I would like to share, that this very guideline which are being discussed were not prepared or not written by the scheduled caste, scheduled tribe or OBC. It was written by the University Grant Commission headed by Dr. Vineet Joshi. Other people, of course. So the way it is being projected, as everything has been done by the scheduled caste, scheduled tribe, OBC in their own favor, which is completely incorrect. Now, so therefore, we as Supreme Court has directed, many people will sit again and they will redesign it. But I'll come to Mr. Chadda's argument. He's an advocate.
Okay.
And being an advocate, he knows the various laws that are made. For example, Dowries Act. If suppose the laws are made not to acquit the culprits, let there be 1,000 criminals be left, no innocent person be punished. So that is the principle of the law. Am I right, Mr. Chadda?
Absolutely.
Now, in this case, so what and how do we, when the government or anybody, even if Mr. Chadda heads a committee, or Ishwar, my colleague that...
Go ahead.
So they have to look into the purpose of the law. What is the purpose of the law? The purpose of this guideline is to bring equity and inclusion.
Yeah.
And let me ask, what is the problem with bringing this equity and inclusion? Okay. And
no, absolutely. The problem is not...
India has a very, a history where the exclusion, discrimination, caste-based atrocities, everything is in very real sense exist.
It exists across the world. Ashokji, it exists across the world. If we as humans, and specifically here as Indians, need to strive for an inclusive society, something that Chadda ji said, that he is for the regulations. He said he is for the regulations.
sorry, Kabir, that across the globe,
Yeah.
there exists such cell in all the university. I was academic board member of the University of South
So,
Australia.
so I think the bottom
Okay.
line is clear. The bottom line
Committees
is
are
clear.
there.
Ashok
Committee
ji,
in the Harvard is there. Everywhere is
this
there.
is not the end of the equity debate. This is not
Yeah.
the end of the equity debate.
That's
But
what I'm
nobody's saying
that-
this is the end of the equity
therefore,
debate.
I suppose
Rahul right now
the-
said,
when
let's not
committees start
use
functioning,
the sweets to rub
the
wounds on other
law has
people's,
not
rub
come
salt
into
on
the
other people's
force and
wounds.
we are
Ashok ji
doubting
said,
the
Ashok ji,
intention.
Mr. Advocate Chadda was here saying that he was for the rules. It's just that the vagueness that the Supreme Court pointed out, let's work around it and we can put more safeguard rails here, and let's hope that this pause is for more precision. That's the only thing.